Daniel Burberry asks me on Quora, if an original name is not officially a trademark and is used as several organizations, can I make it a trademark for mine? I'm Andrei Mincov, the founder of Trademark Factory, and here's my answer to this question. The beauty of this series is that unlike our FAQ playlist, where I summarize and rewrite the question, this is just the raw questions that I get all the time. And sometimes I don't necessarily understand what the question is. This is one of those cases. I'm not exactly sure what Daniel is asking, but let's try to go through this. So he says, if an official name is not officially a trademark, so assume what Daniel is referring to is that the name has not been registered as a trademark and is used as several organizations. This I'm not really sure, but it could mean that the same name is used by several different companies. And whether or not it's used for the same products or services or completely different products and services, I don't know, right? I can't gather this from this question, but probably the most valuable answer would be the assumption that so there are different companies that use the same name, neither of them trademark the name. And so the question is, if that's the case, could Daniel go into the same business under the same name and also try to get a trademark on that name? Because pretty much every other option of every other reading of this question would be less valuable for the rest of us. So let's assume that that's the case. So many companies out there in the same business use the same name. Neither of them have it trademarked. And Daniel comes in and says, well, I'm also going to run this business and I'm also going to run this under this name. And I'm actually go out and try to trademark that. So can you do that? If nobody had trademarked it, and I'm assuming the name is somewhat distinctive and not just a generic name, then you can file your trademark, and unless there's something similar trademarked out there, then the Trademarks Office would approve it. What would also happen is that after the government approves it, it would be published for opposition purposes when anybody, including those other organizations that had been using the same name before, they may raise their hand and oppose your mark, basically asking the Trademarks Office to not register your trademark because that would cause them grief and their interests would be damaged. But assuming they don't do that, assuming they don't oppose, then your trademark would be allowed and then registered. The question is, the next question probably is, could you enforce your newly registered trademark against those other companies that had been using the name before you went to the Trademarks Office and registered the name? Yes and no. So those who have been using it before will retain the right to continue using the brand the same way they used it before. They couldn't expand beyond their geographical area, for example, or beyond the scope of goods and services they were offering, but you couldn't drive them out of the name they had been using before you trademarked the name. Now, by the way, this response is only dealing with countries that recognize common law trademark rights. Most countries actually don't. So if you live in a country that doesn't recognize unregistered trademarks, then if you run to the office and trademark the brand, then you could actually easily enforce it against everyone else, even if they had been using the brand before. Now, if you are in a common law country and that seems like a concern, that your ability to enforce the brand would be limited, and also there would be a risk of your mark being opposed, then, I mean, if you're asking this question, then I think you understand the potential risks. And what you want to think about is it worth it? Is it worth it, and what's the long-term strategy? Is the long-term strategy to get the brand, maybe get some settlements with those prior owners, maybe get some notoriety around this, make a little bit of money and run away? It's one thing. But if you're planning to build a real brand and call it your own, I would say that's not the great strategy to go out there and try to trademark something that you know others are already using. Fernando Gonzalez asks me on Quora, can I use the name of a fictional place from a book for a brand or website? For example, Hogwarts Sky or Frankenstein's Mother. This is really gray area, because in the normal situation, the answer is yes, you can. But in the long run, it really depends on how famous those other brands are, those names are, how many people know about them, and how likely is it that the owner of that IP in those books, that they will be able to prove that you're gaining an unfair advantage by creating the perception that you're somehow linked to or authorized by them. So with Hogwarts, really what's going to happen is their argument would be that by having a product or a service or a website where you're selling something under the brand Hogwarts, you are trying to build a mental link in the market's mind between your products and services, or yourself, and J.K. Rowling and her agents and the film studio and all of that. And they would have a pretty good case there, because they're so well known that anybody who visits your website would know exactly what you're trying to accomplish with that. With more obscure works and books and movies, it becomes less of an issue, because copyright is very different from a trademark. Copyright protects the content itself, like the book, the story, the video, the film, whereas trademarks protect short phrases, short names, maybe images, in connection with specific products and services. So it's not about the actual word. You don't own the word when you trademark the word. You don't own the phrase when you trademark the phrase. You own the mental link between that phrase, word, or image and specific products and services. So simply because you wrote a book and came up with a name of a place or a protagonist or something doesn't mean that you automatically have trademark rights. You don't. You don't have trademark rights for specific products, services, and that creates this tension. So in the opinion of the court, the book, for example, is not known well enough to people, or if it's so clear that your products and services have nothing to do with their book, you may be able to get away with that. But think about this. Here's another angle to this. The more well-known the book, the more money they have to throw at their lawyers to make your life miserable. So whatever advantages you think you may get by calling your product one way or the other would probably be destroyed by them hiring an army of lawyers to go after you and make sure that not only you stop using that name, but you also pay them a hefty amount of money. If you're hoping to build a real business, a really successful business that's going to be out there providing value to the world, I don't think it's the right thing to start that whole relationship with the world by stealing from somebody who had created something that the world admires. Just don't do that. Harris Rothaermel asked me on Quora, how do I legally retain the IP when hiring a developer to write code? This is actually a great question, because if you don't know, just because you hire somebody to create your website and if you pay them, doesn't mean that what they've created for you becomes yours. The intellectual property in the website that you paid for and that you hired them to create for you does not automatically vest in you. It remains with them unless you have an agreement in writing that assigns or transfers their copyright and other intellectual property in what they will have created over to you. And the assumption behind this approach is very simple. The author, the person who's actually creating this, the programmer or the web designer or whoever else is working on your project, by definition, they are the weaker party, because once they've delivered something to you, if they weren't protected by copyright, then you could just say, well, now it's mine, thank you, goodbye. So what has been decided is that they will have the original copyright. They will be considered the original author of the work that they will have created for you. And again, the assumption is that if you, the person who's hiring them and paying the money, are really interested in making sure that you become the owner of whatever IP they're going to create for you, then you would reach out to them and get it settled through a contract. That's what contracts are for, right? So the power of a contract is that it allows you to change the default provisions of how law is treating your relationships. So by default, it's the author, the programmer that owns the IP on the website. But you can change it through a contract, which is why you enter into a contract that says, I own this, but I'm willing to assign it to you in exchange for you paying me and maybe in exchange for something else. So that's how this works. So if you want to make sure that whoever you hire to create your website properly assigns you these rights, you gotta have an agreement in writing that states exactly that you chose them to create something for you and they agreed to design your website, provide you with all the source code and all of that so that you can in the future amend or modify or do whatever you want with that website, and also that for the same amount of money they will have assigned to you all their intellectual property that will subsist in the work product that they will have created for you. So I know it's a mouthful, but the summary is the only way to make sure you retain the IP is sign the contract before they do the work. Simple. And to make it even simpler, we actually have a website where you can purchase the templates for the contracts just like this. This could either be the after the fact assignment agreement, which is after you've hired the developer, they've done your website, and then you watch this video and you go like, whoa, I didn't realize I don't own IP on my website. How do I go back to my developer and make sure that they assign the rights? So that would be the situation after they've done it, after you've paid them. Now you want to go back and say, actually what we meant is for me to own the intellectual property in that website. Can you please sign this? And that's a very short agreement. Or you can have the longer version, we call it content creation agreement, which is something you want to sign before the money changes hands, before they've delivered the work. It's much longer document, much more sophisticated, covers a lot more ground, and think about it, you can never convince somebody who had already done the work and got paid for it to sign a long contract, right? It's just the reality of it. But they'll probably be able to sign a one-pager that briefly outlines what's happening. With people you're hiring for the future, get them to sign the longer one. Like I said, it's a lot more sophisticated, and that's how you protect your intellectual property that your employees or your subcontractors are going to create for you. Now, I hope this answers Harris's question, and if you found it interesting, subscribe now, get notified whenever the next one goes live, and I can answer a question that you have about branding or trademarks. The only way for me to find out is for you to put a comment below, and I'll be happy to record a comment just like this one and help you and maybe help somebody else understand how trademarks work. Until then, I'll see you in the next video.